Now, what if you possess property, but you don't own it? Now we're in the area of landlord-tenant law. Big issue. Again, if the video is helpful to you, put a like on it, subscribe to the channel, tell anyone you know who's interested in law or studying law, hopefully interested, that these videos are out here.
Now we're on to the fifth level 1 topic, landlord-tenant. This is a huge area of the law. The first thing we recommend is that you type it. So it's either going to be a tenancy for years, a periodic tenancy, tenancy at will, or tenancy at suffrage. Tenancy for years has a beginning and end date fixed at the outset. No notice is required. It expires automatically. Contrast periodic tenancy. This continues for successive periods until terminated with adequate notice. So, such as a month to month, every 30 days. Tenancy at will, this will terminate at will by either party. You can't have these being one-sided. If one side has the option to terminate at will, the other side automatically has the same option. Tenancy at sufferance is mainly for someone who was in rightful possession and then remains wrongfully. So that's your holdover tenant hypo. So decide what kind of tenancy you have, and then in your thinking, not necessarily in the order that you analyze, but certainly your thinking, you've got to think of the duties of the landlord. Now, in your analysis, in your approach to landlord-tenant, you want to start thinking of what are the duties of the landlord and have any of these duties been breached? The landlord, under the modern majority, has the duty to deliver actual possession. Landlord has the duty to make repairs. Now, don't forget, on your hypos, you've got to give your landlord some notice. And later we'll talk about the tenant's duty not to commit waste and to mitigate. So, deliver possession, actual repairs, and then quiet use and enjoyment. Basically what this means is the tenant has the right to use the tenant's estate, which is a leasehold estate, without being thrown off the premises, and making sure that where the tenant lives is fit for human habitation. Well, if they evict you illegally, total eviction, let's say the landlord doesn't want you in your leasehold estate and locks you out, that's a total eviction, then all of your obligations as a tenant will cease. And as a tenant, you can either seek damages, you can cover, you can go to another apartment and sue the landlord for the difference, and you could even get special damages, including, for example, hotels and meals. So landlords don't want to do that. You can have a partial eviction, but more important, the most important, is your constructive eviction. And I want you to learn this one by the elements, because on bar exams, typically they will test this one by the element. So if a tenant wants to claim constructive eviction under this covenant of quiet use and enjoyment, the tenant must show the following elements. Number one, the landlord has to be at fault. Number two, there has to be substantial interference with the habitability of the premises. So basically a stench coming from a dumpster that the landlord put there, right under your sink or right under your bedroom. That's pretty substantial. Or the toilets don't work in the bathroom. That's pretty substantial. Or there are leaks all over the place and they ruin your furniture. That's pretty substantial. Now here's the kicker, element number three. The tenant under this particular legal theory must vacate within a reasonable time. At that point, then, the tenant's obligations to pay rent are excused. Now, what frequently happens on essay exams on bars across the country is the tenant does not leave. Therefore, if you go through all the elements, you'll find you won't be able to meet these elements. Should you discuss them? Yes, you should. You can meet some elements, not meet some elements, and tell a bar examiner this particular legal theory will not work, assuming the tenant stayed. And that's what the typical tenant does. Now, there's a second theory, the warranty of habitability. And by the way, if you discuss one, you should discuss both. Just remember that the warranty of habitability applies only to residential, whereas the covenant of quiet use and enjoyment, constructive eviction, applies to residential and commercial. Now, under your warranty of habitability, the rule is the landlord must provide property that's reasonably suited to residential use or fit for human habitation. Thus, its restriction to residential properties. Now, if this warranty is breached, then the tenant may move out under the previously discussed constructive eviction theory. As indicated, tenants on bar hypos rarely move out. So then, under this theory, warranty of habitability, they can actually stay and sue for damages. So if they stay, they're under this warranty. And they can also repair and deduct, assuming you've given the landlord some adequate notice. All right, now that we've covered the duties of the landlord, let's look at the duties of the tenant. The main duty of the tenant, duty that runs with the land, a covenant that runs with the land, is the tenant has the duty to pay rent. And of course, that is the usual duty that's breached on bar exams. The tenant stops paying rent. Tenant thinks that the tenant can stop paying rent, stops paying rent, as opposed to staying, continuing to pay rent, which is what you should do, and suing for damages, or repairing and deduct. That's fine, that'll work, but you got to pay your rent. Keep paying your rent. That's the biggest mistake that tenants make. They fail to pay their rent. Now, another duty of the tenant is the duty to make ordinary minor repairs. So, for example, let's just say it's Friday night, the landlord is gone for the weekend, or you can't reach your landlord, and you notice a little drip under your sink in the kitchen or bathroom. Well, the landlord has the duty to repair, right? So why don't we just let that go, and we could let it wreck the carpet and maybe wreck the walls, and we'll get this whole thing repainted and destroy the carpet, get a new carpet. You can't do that. You have to take at least some action to prevent further damage. So ordinary repairs. Now the big one, in addition to rent, is you may not commit waste. So here we go again with that concept of waste, which we discussed in Life Estates. Now there are three types of waste, and generally you should discuss all three. We have affirmative waste, permissive waste, and ameliorating waste. Affirmative waste is intentional. Now you're saying, well, who would do that? I'll tell you who. Are you living in an apartment? Then I'd say you. Well, did you ever hammer a nail into a wall in your apartment so you could hang a picture? You've intentionally damaged those premises, haven't you? So that's affirmative waste. Permissive waste, I discussed it. It's the failure to make these ordinary repairs. And ameliorating waste is where you make, and let's put this in quotes, an improvement. And to you it's an improvement, but to your landlord it's not. So, for example, we had a bar hypo where the tenant put in a jacuzzi and mirrored ceilings. Thought it was a great improvement. Landlord disagreed. And so that's ameliorating waste. In a sense, you could say I put money into this property. But the landlord's claim is, look, I can't rent it this way. It looks like the kind of place that decent people wouldn't live. So that's ameliorating waste. Now, an issue when we talk about tenants is the issue of fixtures. Now, fixture is when you bring chattel, personal property, and you bring it to the leasehold estate. So let's say you remodel and put the jacuzzi. That could become a fixture. Let's say you put in track lights. That may become a fixture. Let's say you do a complete remodel and you change the toilets and you change the faucets and you make all sorts of changes. Those could all be fixtures. Now, chattel's so affixed to the land that it becomes part of the land, becomes the property of the landowner. There are some exceptions to this general rule. Basically, there are factors the court will consider if you have a fixture and you're fighting with your landlord over whether you can take it off once you've put it on. Well, one is the degree of attachment. How attaches a jacuzzi that's basically blended in with pipes underneath and the whole ball of wax. That's pretty strongly affixed to the realty. Now remember, these are factors, so the court will weigh them all. The harm to the premises, if the fixture is removed, is the second factor. The third factor the court will consider is this fixture specially made for the realty? Because if it is, well, it's more likely to be part of the realty. And the fourth factor is the intent of the attacher. In other words, did the attacher intend this to be part of the realty or something that the attacher would take with them when they left? And finally, the degree of ownership or length of the lease. If it's a 25-year lease and the fixtures all go in on year one, I think there's going to be a pretty strong argument that those fixtures should stay when the tenant goes. Now, if the tenant does remove a fixture, the tenant must be able to make repairs and actually make the repairs and remove the fixture before the tenant vacates. Now, what happens when the tenant violates the tenant's duties? What are the landlord's remedies? Well, the main duty, again, is the failure to pay rent. And what the landlord does is called an unlawful detainer action. In this business, you do not take self-help. Do not change the locks. Don't forget, you'll be subjected to damages, specials, and so on. But you can move to reclaim the premises. You can terminate the lease, you can sue for damages, and you can evict. So you can do any of those or any and all. Now, if the tenant abandons, say just goes away, one thing you have to remember, you're going to have, as a landlord, a duty to mitigate. That means you must try to reduce or minimize the damages. You must re-rent, if possible, on the tenant's account. Now, if they actually abandon, the law in the majority of states gives the landlord, again, a range of remedies. One, what the landlord can do, it's impractical in most cases, but can sue for damages, basically lost rent and any harm to the premises. The landlord can treat it as a surrender. Under those circumstances, the tenant's duties and liabilities end. The landlord may re-rent on the tenant's account, and of course if the landlord gets more or the same amount of rent, it's a wash and the tenant is at least out of the woods, and as long as those premises stay rented. Now, the tenant's defenses will be, number one, duty to mitigate. The tenant will say the landlord failed to mitigate. Number two, retaliatory eviction. Basically, a retaliatory eviction occurs when the landlord is taking action against the tenant for exercising some right. So, for example, let's say there's a code violation, and the tenant brings this to the attention of the landlord. The landlord says, too bad, like it or lump it, and the tenant reports the landlord. So the landlord evicts. This is called the retaliatory eviction. And the landlord may not evict whenever the tenant exercises a legal right. And retaliatory eviction is presumed if the landlord evicts within 3 to 6 months of the tenant's exercise of a legal right, or even the report of a defect of a code violation. The third defense, which we've discussed, and it's actually a combination of defenses: quiet use and enjoyment, constructive eviction, basically we've discussed, and then the implied warranty of habitability. And when you discuss one, constructive eviction, discuss the other, implied warranty of habitability. They run in a pack, so you need to talk about both. Now we get into this interesting area of assignment and sublease. And this occurs where we have a tenant, and the tenant decides, or circumstances cause the tenant to leave before the end of the lease. So what can the tenant do? The tenant has a choice. The tenant could try to assign the tenant's interest to another party. So you take over my rental obligations, you live here. That's an assignment. An assignment occurs where you have a complete transfer of all interest. Now, in a sublease is a partial transfer. So let's say you have a tenancy for 5 years, and let's further say that you, after living there 1 year, you decide that you must go to Europe for 2 years. So you sublease your 5-year leasehold estate, and you sublease 2 of your 4 remaining years to a third party. That's called a sublease. And we're going to discuss the implications of both assignment and sublease. Now, the thing I want you to remember is this: if you sign a lease, you are in privity of contract for the duration of the lease, meaning that you've signed an agreement with the landlord, and you're going to be liable for all of the covenants that run with the land and that are in that lease for the duration of the lease. So therefore, if you have a 5-year leasehold estate and you sign a contract, then for that 5 years, no matter if you assign or sublease, you will be liable for paying the rent, essentially, and damages to those premises. All right? Now, there's another legal theory that landlords can use. It's under property law. Whenever one moves onto the estate of another, they are said to be in privity of estate with that individual. So if we have a complete assignment where tenant 1 gives up all of tenant 1's interest, tenant 1 remains in privity of contract with the landlord, and then whoever accepted that assignment, the new tenant, once that new tenant moves on to the leasehold estate, that tenant is now in privity of estate with the landlord and is going to be liable to the landlord under property law for all the covenants that run with the land. So the landlord now has two causes of action. One against tenant 1, with whom he was in privity of contract, and one against tenant 2, who is now in privity of estate. Now, sublease is much different. In a sublease, there is no privity of contract or estate between the landlord and the new tenant. Basically, tenant 1 is in privity of contract, and also when tenant 2 moves onto the property, look at it this way. Tenant 1 has a 5-year leasehold estate. Tenant 1 subleases, which means partial transfer. Tenant 2 moves on to tenant 1's 5-year leasehold estate and is actually in privity of estate with tenant 1, not with landlord. That's the difference between assignment and sublease. The only way to get out of these things, and the only way to get out of privity of contract, is if you have a novation. This is a brand new contract where all the parties agree and the landlord agrees to relieve tenant 1 of tenant 1's duties. Otherwise, tenant 1, remember, is going to be liable to the landlord under the lease under privity of contract throughout the duration of the lease. So that's landlord-tenant.